So with that, I'm going to turn it over to you, Heather.
Well, hi, I'm Heather Cameron, Director of Legal Risk Mitigation, aka Director of Nonsense and Shenanigans, former claims and litigation peep. Now I work on the legal content team where we're basically the dental hygienists of Getty Images looking for things that don't belong or that need to move around and go someplace else. And I love to consult with customers about indemnification, about making good choices. And Nancy on this panel is one of my IP mentors, going back 25 years now, Nancy. I love it. Margaret, over to you.
Yeah, so I'm Margaret Vincent. I am the VP Legal and Advocacy at Stocksy United Co-op. I also have the great honor of being the current chair of the DMLA Legal Committee. So very excited to be here today with all of these lovely folks, and another, shout out for the conference where we will be doing more talking about important legal things for you to learn. Nancy.
Hi, well, most people probably know me. I'm Nancy Wolff, and I've been counsel to DMLA for many years and many of its members as well. And I have an awesome legal committee, and thank you, Margaret, for hosting it. And yeah, we have fun talking about releases, and we're on the third part, people, places, and things. So I think we should just start talking about things.
Okay, well, we love the topic so much. We had to make this whole entire series. So in case you've missed it, I don't know how you could have possibly missed it, but in case you missed it, you can see versions 1 and 2 on the DMLA website. I think Margaret's going to post some links for you.
I was going to, and I have them ready, and it appears I cannot post to everyone in the chat.
It's all right.
I apologize.
It's all right. We'll take care of it.
Okay. I will work on that.
Perfect. Awesome. Leslie, I can send them to you.
I love it. So we love this particular image to kick things off because when you think about the category of things, it can be so many things. It can involve trademark protected objects in a particular situation or a place. It could be copyrighted works that might be lurking around in areas that require permission. So we're going to kick it off thinking about what these intellectual property rights really are and when they matter depending on the use. So, Margaret, copyright. What do you think about copyright in this context? Oh, Margaret's on mute.
It's not a Zoom without me talking long.
Oh, you love it.
And I just was able to post the links to people and places.
Oh, thank you.
Highly recommend. My team and I have been watching. That's been great. So copyright, yes. So copyright is something that we are probably all fairly familiar with in this bunch, but always good to sort of do a reminder. So when you're thinking about things, copyright is this core intellectual property right that we need to understand and respect. Things that you can you can protect that are protected by copyright can be any number of things. Sculptures, paintings, photos, maps, globes, sheet music, wallpaper design, anything that is creation. I tend to try and remember copyright equals creator when I'm trying to sort out copyright and trademark in my head. But Nancy, do you want to go ahead and talk a little bit about trademark?
Just to also maybe to add something, if you're doing videos, the one thing you also really need to worry about with copyright is if there's any audible background music. So I don't want to forget that. So copyright protects certain rights under the Copyright Act, and it's visual work, it's literary work, and audiovisual works, and music, and it also could be things like dance sometimes, and things like that. Even we might have talked about last time, like light shows. So we'll get into that.
Talk about that again,
copyright, because it protects creative works, it deals with reproduction and distribution. And so most reproductions, even if it's within a background of an image or part of it, could have some potential risk unless there's an exclusion. And when it comes to trademarks, you're looking at a different type of IP. They all get bundled up as IP, but trademark is very different from copyright because it's almost like a consumer protection law instead of a law that deals with the reproduction of something creative. It's intended to be a source identifier of goods and services. And if you look on the screen, there's a TM and there's an R. And I have to say that unless you have a registered trademark, do not use the R, because then you might not get your trademark. So under US law, and again, as a background, copyright, trademarks, they're all the laws of the country. So there is no such thing as international trademark law, international copyright law. There are laws of each country, and we have treaties, and you can, get trademarks registered in many different countries, but for our purposes, we're going to mostly talk about US law here. So in the US, which is different than a lot of countries, you can have rights just based on use without registration. So some way to try to determine if there's trademark rights in something is you would check the USPTO website, but that doesn't cover everything in the US because we do have rights from use. So they're source identifiers, and it could be very broad. It could be the shape of a bottle. It could be the logo. It could be the name. And so there's different source identifiers that have protection under US law, but not every reproduction is a violation because, again, there has to be some kind of trademark use. And so you'll see in our next slides how you can have objects in pictures and not always worry about them because it depends on the context.
Yeah. And this can just be our quick refresher, as we've talked about this in both people and places previously. The context of use is always key, as Nancy talks about. And as Heather and I have discussed as we've gone through this series, customers like to blur that line. No, this is actually editorial, but it's an advertorial or things like that. So it's always good to remember why this is so important. And Nancy, did you want to add a little there?
Yes, it is very important because we meaning all of us, particularly in the US, the concept of editorial use gives you a lot more broad usage of anything. Editorial use is a use that's informational, newsworthy, but it doesn't have to be about hard news. It could be about something cultural. It could be about a sporting event. It could be about a concert, a play, a movie. It's just you're truthfully reporting on a subject. And we have, as in we, the US, the First Amendment, which gives us a lot more leeway than other countries that don't have it, because we protect not only freedom of the press, which is newsworthy, but freedom of expression, which also includes things like visual arts, photographs, videos, and things like that. So when you're using content to illustrate anything that's informational, educational, not selling goods and services, you don't need releases the way you would if you're using an image to sell a product, a service. You're trying to promote your company, you're trying to raise money and fundraise, you're doing product packaging and design, or an endorsement. So that line is very important, and it's very important when you're licensing to know that which uses will require releases and which ones won't, which is why generally terms and conditions of use will sort of want to put it on the customer to make sure they know what they're doing, because in this e-commerce world, you're never going to know what all your customers are using something for. So whether there's a release or not makes a lot of difference of how an image could be used. Could be perfectly fine to have a picture of Taylor Swift when you're talking about her Eras tour, or her, or even how much she maybe influenced people to go out and vote. But then you can't use a picture of her to try to sell your own products and goods and services. So,
and that's usually why. So a royalty-free collection is all commercial cleared, and covers all those possible commercial uses.
Yeah. Okay. Moving on. Releases for things. We've talked about this a little bit, but I just want to encourage everybody listening think about your props. When you're going to do a photo shoot, please think about your props. Just because it's a ubiquitous household object that you've grown up with, that you've seen over and over again, every time you open your refrigerator and look at your condiments, they're just, these household objects, but it doesn't matter. They can still have rights that we have to think through. So Nancy, we've talked about this in other webinars before, but why do you want to think about having releases for things?
Well, you want to have permission. So if it is being used in a way, there is an actual association. And this gets very subtle because you have those product shots where you only have a product in the background, which may be okay for a lot of uses and maybe not okay for a lot of commercial uses. And then this is also an area where you have to be concerned about international marketing, because under US law, there are certain things that are not protected, like useful objects don't have much protection unless it is really a trade dress where someone always knows the source when you look at it. But in other countries, high-end things like certain modern furniture could have rights that you would not have in the US because we don't protect useful objects. So when you're going to someone's home and you're doing a shoot, that's where you really have to be careful, because people collect a lot of things and they may not own the art that's in the background. They may have a sculpture on the desk. There may be a very uniquely shaped laptop or device, or even phonograph,
Kids' toys,
or kids' toys and kids' art.
Doing
So
UGC style capture what's really in a space, you still have to be really careful about all these restrictions so you can actually get your content through commercially.
We're going to show you lots of examples in just a moment, but a really quick refresher. We've looked at the property release before in the context of places. In the first webinar, we looked at the model release, and so we looked at the property release last time. But you can also be thoughtful about using a property release, not just, for private homes, but also for like, what is going on? Like, does somebody own the artwork? Do you have permission for that? Nancy, do you want to talk, or Margaret, do you want to chime in about what you think about that for release?
Right. And the cautionary thing is that a lot of people don't really understand that copyright is an intangible right. So you can go to your Target and buy this great poster and put it on your wall, and you own that physical object, but you don't own the art that's within it. So if you say, sure, you can take photos in my house, I'll sign this release, but you really can't sign away someone else's copyright or someone else's trademark. So even if you might have one of these, you have to make sure that what you're asking them to sign off. Now, if it's their kids' artwork, you could get a release for that. Or if they happen to be an artist, or family photos, you could get releases for those. But if someone else created the work, this release will not cover. And that's just a precautionary tale.
Indeed. And then
when you do a shoot, don't make the main object of your pictures any of these kinds of objects that could be protected by either copyright or trademark. They should be incidental, blurred, or just
gone.
If you're advising your photographers what to do, sort of have some do's and don'ts along those lines.
Indeed. And whether or not release is legally required, we talked last time about property releases and strange legality elements around them, but the real important piece here is to have releases to eliminate friction with buyers, which is what we want in order to achieve sales. And most ad agencies and brand customers require property releases too, so that they know that they're protected. It just makes images much more marketable to have that in place. As well, having records of your series creation and releases on file makes for great metadata. And that's also useful for merchandising the right content to the right audiences at the right time, which is another thing you want when you're trying to sell your work.
That's really true. And I like to say too, anytime a customer has to contact us to say, okay, I get that the house is released, but what about this thing hanging on the wall, or what about the skis, or what about the tennis shoes I see in the corner? What about the rugby ball? What about all of those elements? Anytime a customer has had to call and sort of ask if it's not obvious, everybody's kind of lost money at that point, which is not fun. And then if you have to break their heart if they fall in love with a photo, then you realize, oh, we shouldn't have accepted that photo. There's that recognizable object. Then it, a little bit could erode confidence in what we're doing here. So we definitely have a policy. I know Margaret shares the same one. If you see something, say something, because we would much rather deal with that right then, clean it up, see if, we can help alter the photo to make it work for the client. But,
Yeah.
After the
more
fact.
The more eyes with an awareness of what can be an issue is super helpful. So
super helpful.
Okay, Heather, we do have our first question.
Oh, sure.
I saw that.
And this is one you guys have dealt with. I know but it's a very common and interesting one. There's a famous example in California of the owners of the Pebble Beach Golf Club claiming that they own the trademark to the specific tree on the property, lone cypress, and pursuing photographers who sell images of it. Is that valid?
Okay, well, that'll get us to our next slide, and I'll incorporate that question when I
Great one.
about it.
yeah.
So good timing. So we're going to talk about what trademarks in the wild. I'll talk about Hollywood, and then I will talk about my dealings with the Pebble Beach Club, which hasn't had a question in a long time on that one. So that'll be good. So as I was talking a little bit before, trademarks are a little different than copyrights in that not all reproductions raise a trademark use. So if you're driving by Hollywood, there is the Hollywood Hills has the block letters of Hollywood, which has become ubiquitous for identifying this geographic area. So these words can be associated with just the geographic area of California, and that's not a trademark use. The interesting thing about the Hollywood sign is that it's owned by the Chamber of Commerce. And so when people drive by the Hollywood sign, they do not automatically say, oh, Hollywood Chamber of Commerce. There's really no association. So the Chamber of Commerce has made some registrations for the mark, but it's when you register trademarks, you have to identify goods and services where that mark is in use. And so they have a very limited number of uses they can use because it is a geographic identifier. So they have, I believe, one that's in the licensing area. And I think in many ways their uses are a little bit tenable because people don't associate them with many goods and services. However, there's also the squeaky wheel, sort of, you would call it the pain in the ass thing. So I suspect that many television shows and any kind of entertainment property that uses this might get a letter from them. And so they get in the practice of licensing, and then they expect everyone should have to license. But there's so many uses of this word that doesn't require a license. And I know I've had experience where even people have used them in advertising, but it's really as a geographic locator, and we've been able to have some communications about that. But this is just an example of sort of how sometimes words like that are sort of used in a creative way and aren't really on a branded product don't really fit the trademark model, but you still can get claims and you still can get friction. You can still take pictures of this sign, and there's loads of editorial uses and probably a broad range of other uses. But it's one of these that we probably put on the DMO list because it's like a problem child. And I don't know if Heather wants to pop in, and then I'll talk about the Pebble Beach.
Well, they do like to enforce their rights. you know, for sure. And even if we disagree when we think that they have them, they can just be very pursuant. And that's sort of a general, I know we're probably going to get to this in a different place in this webinar. Just a great reminder for this audience that trademark owners, they really do have an affirmative obligation to make sure that they are monitoring, you know, space and time for how people may be, you know, using or infringing on their IP portfolio and make a big fuss. They're kind of obligated to be looking at that in order to maintain their marks. And so as we learn about things, and you know, there's going to be some great examples of like, I never knew that. You're going to, Nancy and I discovered some of these together actually, that we're going to talk about. But definitely talk about Pebble Beach, because we've certainly heard from them before. It's certainly private property, you know, to get out there to actually see the physical tree. But Nancy, you're really great at talking about, there's a difference between a physical thing that you're taking a photograph of and then an actual design mark.
I was going to get into that. And just a reminder that even though trademark's a different body of law, there is also something called fair use in trademarks. And I don't want to go into all the things, but nominative fair use. So you can always talk about like Hollywood and where it is, and for example, show this. But when you register a trademark, you have to register the specific words or a particular design if you want a design mark. And what makes a trademark is the repetition and the same use over and over and over, so that consumers will recognize it. So when you see a swoosh on a Nike hat, you know it's Nike. So when you see a tree growing, a cypress tree on a point, you think, oh, that's the lone cypress tree made famous by Ansel Adams. It's a tree. It is not a design mark.
That's what the lawyers think when they look at it.
Right. So if you go to the U.S. Trademark Office, you will see that Pebble Beach has the words Pebble Beach, and they have an illustration of a tree. An illustration is not a tree. And I remember the first time I got a claim from Pebble Beach, I was like, I wonder what they use as a deposit. Did they bring the tree in? Does the trademark office have to water this? Because a real tree is not a mark. And it's like why a building is very difficult. I know in the places we talked about the Rock and Roll Hall of Fame and how the court said that that building itself didn't serve as a trademark because you could look at it from any angle, day and night, above, below. Because what makes a strong mark is the element that's associated with the goods and services is used the same way over and over and over again. And so a tree, you can get at different angles. You can have it at sunset. You could have it at night. You could have it at day. It isn't serve as a trademark. It's not acting as goods and services. So again, Pebble Beach was very aggressive at a period of time about trying to monitor anyone who was actually taking pictures of the Pebble Beach tree and using it for anything other than personal use. I don't think they had a legal basis, but they caused enough anguish that people did not want those images in any commercial library. And I have not had complaints lately, so I don't know if they've changed owner or if they're aggressive as used to be or not. But it is the tree is not a trademark.
Tomorrow, when you get
their little logo might be, their little design element on their golf carts or their hats or something, but the tree itself is a landmark and made famous years before it was a golf course. And it's on that 1 mile drive, and it's, what can we say?
Well, while we're talking about the shapes of trees and illustrations of trees, let's talk a little bit about these. I just want to preface this that every single photo that you are seeing here, are these in the Getty Images Creative royalty-free collection available for all commercial use? No, they're all in our editorial use only, intended for editorial use collections by design. But we just thought we would walk you through some different ones that many people know. Also, there's some really great lists that are out there that you can refer to. Just the shape of the Coca-Cola bottle. It doesn't have to have the Coca-Cola logo on it. It doesn't have to have the red and white. It can just be the bottle by itself. The shape of the bottle is a design mark. Absolute, same thing. Doesn't matter if it says Absolute on the vodka bottle, the shape of the bottle. Kikkoman soy sauce bottle. This is the industrial designer who designed it too. Isn't he charming? The shape of that bottle is protected. John Deere with colors. You know, the signature green and yellow is very identifiable as a John Deere tractor. Tabasco, the shape of the Tabasco bottle protected. Nancy and I know a little bit about KitchenAid and the KitchenAid stand mixer. The shape of the stand mixer, design mark.
Yep.
Tiffany blue, that's a thing. And those red-soled shoes, Christian Louboutin. So just note to selves. There are so many examples.
Stand in those shoes, right? Those are.
I know, but aren't they elegant? They're so elegant. There's so many other things that we could talk about here with colors. You know, there's UPS brown, there's Barbie pink, there's Target red. There are stripes and swooshes on shoes and sneakers. There's the Grand Central Station clocks, both the gold clock inside and the sculptural clock on the outside.
Oh, and let me toss in one more. Not just things on the exterior of shoes, it can be shoe soles as well.
Just like the red soles.
Treads.
Yep.
And
the
treads.
Waffle weave soles.
Yep. I mean, it's too many. I mean, we could fill so many pages with examples of things. We're gonna keep going. I know this is one of Margaret's favorites. Margaret, you want to talk about some of these fun things?
It is. This is my favorite topic. So,
Snacks.
Like toys and snacks, which I really think you can't go wrong with. So the first time I was digging into trademarks and trade dress, these were the sort of items where I was like, kidding. But sure enough, these are protected designs. So unacceptable for commercial use for the most part. The shape of the goldfish cracker and the little Hershey kiss with the flag. The Rubik's Cube, Lindt chocolate bunnies, Legos. Although I will say that Stocksy, at least, we have we will allow general Lego blocks. So like parts of this image that just show the rectangular ones, that could be okay. We don't allow specialty blocks or blocks from specialty collections. So that can be a thing. I would also say we see a distinction with the Slinky. That metal classic Slinky is absolutely protected. The plastic versions, not as much. I hope I didn't just jinx that. But yeah, these are all, these are all things to think about and keep in mind as this is why we suggest checking lists, because there's a ton of these things that we don't have on shown, but would also fall here. Viewmaster, Marshmallow Pete's, Panda Licorice. There really are a ton of things, and you take a look at the known image restriction lists. You'll be surprised what you learn. I'll admit I learned some things as we prepared for this. So
I learn new things all the time.
Yeah,
and also
ongoing. Yeah.
And I would say the USPTO website has gotten so much easier to do some searching if you're searching under brand names.
Search, yes.
It's so much better. Thank you, USPTO. And I also am a really big fan of the WIPO global brand database. I think that those are really great resources to look things up if you're thinking through props.
Ladies, we do have a related question. I'm going to start with the second one. We have three, actually. Removing a logo from a car, is that enough? Or as you say, is the shape of the car protected?
Oh, we're going to look at that. What a setup. I mean, I can't make this up, Leslie.
And the lawyer answer as always is, it depends. Yeah, so certain cars, you can just remove the identifiable logos. Certain cars have trademarks on designs like the front grille or marks that are the entire shape of the car. Nancy, that was the high level overview, but
right. And sometimes you can do the side level of a car and not the front on, because there may be example like the shape of a grille. And there's certain cars that have such distinctive shapes, like a Mini or the old Beetle, that it would be recognizable no matter what angle you have it. And again, the context would matter because, I mean, if you think too hard about it, you could never take any photograph for stock where people are actually doing any usual thing like eating in a diner or walking to school, because everything you wear and do, you know, it could potentially be someone's product. So I think there's and sometimes a difference between an incidental use of an object that's within a scene and something where the object is the most prominent image in the picture, like this Chanel number 5 here. So it isn't like you can't ever take a photo that has objects in it. It's just you have to really be careful that you're using it just in the way you would normally always use that object or your setup is, and that this one object is not so prominent that if someone licenses it for commercial use, they might think there's an association. So with that car, if someone licensed it and they were pretending to be the authorized, is that a Peugeot dealer for that brand, which someone I'm here that knows cars better than me would probably know it right away. To me, it looks like it might be Peugeot.
A Porsche.
A
The
Porsche.
fancy Porsche that has
Porsche,
copyright design for the shape,
Okay. I
in
like
addition to all the logos having
Yeah.
Trademark
trademark
and
protection.
copyright play. Yep.
Mhm.
Yeah, that
Yeah.
is a fancy Porsche. Okay.
And I know Margaret's got lots of experience. So does my team. My legal content team is looking at bottles a lot. Bottles are very
Bottles are
popular.
very interesting. There's a lot of, you know, between alcohol and perfume
Human liquor.
that
Yep.
really protect their shape and register
Yep.
their shape.
Coca-Cola started it, I'm sure.
Yep.
Everybody's
we
on
have-
that bandwagon.
Tequila bottles. Watch out.
I know. Just a note to self, we have the Rolling Stones here, not because I want Keith to come for me, because I know Keith could, but I just sort of love this image because the headstocks on guitars are really important to watch out for. The Fender, Ron Wood's playing a Fender Stratocaster,
Mhm.
and Keith's actually playing a Gibson, that mustache sort of design at the end of a Gibson headstock. Gibson and Fender both are very thoughtful and are out looking at the marketplace. You wouldn't want to have a full frontal Fender or Gibson headstock on display.
And let me just say, Gibson has a beautiful page that shows all of their visual trademarks, and I wish everyone did.
That is good. We should actually link to that if we haven't already in our IP wiki. I'm going to talk to Scott and Lee about
I'll
that.
send it over to you.
after
Yeah.
the call.
It's a really, it's a
And then
really helpful page.
here is Sam Cooke, so handsome, singing into a Shure, SHURE microphone. This is a photo from Claflin University's HBCU collection on gettyimages.com. That Shure microphone has oft been repeated. There's lots of knockoffs too that can kind of come up. This comes up with different types of cookies. The knockoff of an Oreo cookie. Oreo cares a lot about knockoffs and a lot about their own cookies. They're going to let you know what they think about that. There's just so many opportunities to not make something the sole focus of the image. Just be a little more creative, right, Margaret? Right?
Heather,
And then,
to that point, can I give you another question? Because it
Sure.
relates to the making of the sole focus. An image in a bar to promote the bar and shared to various outlets who also promote the bar. Can bottle labels be seen in multiples, but not one singled out? Assume a bartender, I assume a bartender holding a branded bottle would be an issue.
We're feeling really smug and superior right now. That's why you got a lot of facial expression, because we actually are going to talk about that specifically.
You have a slide for that too.
It's really good.
Nice.
We're definitely going to get to that. Okay, so really quickly, before we move on to the next
Let's
thing,
talk about handbags.
We are going to get to that question. Oh yeah, handbags. You know, the Meta Birkin's NFT case too. But anyway, Nancy, go for it. Handbags.
Yes. So as I said, useful objects are not protected. And a handbag is generally a useful object. So I guess in some cases, if it was so sculptural and no one knew what it was, it could be a work of art as well. But that is why a lot of the brands will put their logos all over a handbag or somewhere, or may have some distinctive, like that little lock is often on, which bag is that?
This is an Hermes.
Hermes, yes, Hermes. Yeah, and these are like thousands of dollar bags here. So, and
Yeah.
unfortunately, they are knockoffs. They also get very upset if they are knockoffs.
I remember a photographer doing a photo shoot of a car that had upholstery that looked like it was the Louis Vuitton,
logo.
outside, logo, and outside of a handbag, kind of thing that you would see on Louis Vuitton luggage.
Yeah.
And it was absolutely not Louis Vuitton fabric. It was a knockoff. And these luxury brands don't play. They do not like it. In fact, this photo that you see here on the bottom right, where you can see a handcuff around the watch, that's actually from an exhibit on counterfeit goods. So that's a faux Chopard watch, a faux Louis Vuitton scarf, of fake perfume, Hypnos perfume. So just again, brands are definitely watching, and they're asking regulatory agencies, please help us cut down on this counterfeiting. And France, especially with their luxury goods market, they take it very seriously and don't play. So just watch out.
Speaking of that, Heather, when images come in with keywords and they have luxury brands, how do you handle things like that?
Yeah, we obviously, for our editorial content, it's really important to have everything very accurately labeled. Like we want to know what it is so that we make it searchable and findable for editorial customers who are writing articles or making documentaries. It's important to know what things are. But at Getty Images, when we have content coming in, sometimes we see a lot. We talked about spam keywording, where photographers still think it's a really great idea. If I just include like 28 million brand names in here, and somebody goes on the website to look for that, isn't that great? Because I can sort of maximize the amount of time somebody might see my photo, and maybe even if they weren't looking for this, they would license it anyway. No, for commercial, creative, royalty free, we don't want it. We don't want it in your caption. We don't want it in your spam keywords. We don't like it. Now, customers think about everyday common objects with brand names in mind. People will think they don't automatically associate an ice resurfacing machine from a hockey game with, they don't automatically know that that's what it's called. They think it's a Zamboni, right? Because that's the word that we all know and love. But I can tell you, Zamboni is not a fan if anybody has submitted a photo of their ice resurfacing machine, and it's not their ice resurfacing machine. That happens a lot. There are some competitor brands that make ice resurfacing machines, and it's wrong to call it a Zamboni. They will let us know. But that'll come up like with Kleenex. People will look for Kleenex, and we're like, well, that's how people think, and that's how people search. But we're going to show you, a setup with boxes of tissues. We're not trying to trade off of Kleenex, but that's how people think when they're in the UK and they're thinking about looking for a photo of someone vacuuming. We say vacuuming in the States, but you definitely want to look at pictures of people hoovering. And we're not trying to, profit off of Hoover in any way. That's just what people call that particular common object, and we're going to show results for vacuums.
Right.
But it is awkward. We're having to kind of balance how people like to search with respecting intellectual property rights, because we're all intellectual property companies at the end of the day.
And in fact, using a brand as a search term is very different than using the brand name in connection with goods and service. And there has been cases because of search engines online where a word being used solely for search purposes is not considered a trademark use. So that you can put trademark in for searching
in keywords under that idea. But again, it would be, be careful about calling attention.
Right. And again, a lot of this is all context, because I remember years ago a claim, I think might have been with you, Heather, where someone did a book cover with just the Shure microphone on the cover, but it was a book about public speaking. And because
Right.
that was sort of the iconic microphone,
Microphone,
there
right.
was a relationship between the book and the microphone, and that was not, in my opinion, a trademark use at all. So that's why all these things are very subtle, and you have to think about context.
Yeah.
So
And
Heather, as
Mhm.
you proceed, we've got a question about transformation. So I don't know where that'll fit in. And the
Mm.
question is, if an artist uses one of these things, like you were talking about in the last slide in a painting, is that considered transformative and okay? Or do they need to clear the permission, thinking Warhol's Campbell soup paintings?
oh,
And then there's a
I'll take that.
follow-up.
Hmm.
Yeah, and then there's
Yeah,
a follow-up to the bar question.
You want me to
Stock.
yeah, we'll
Oh,
get to the bar question. Yeah.
okay.
So
Well, I was
and
just
I can
gonna
respond to
let
the
you know what the,
follow-up.
okay,
yeah,
perfect.
yeah, we'll get to that
I'll
one.
type out the follow-up. Yeah.
I'll talk about a painting. So as I said, trademarks have their own body of fair use that's separate from the copyright fair use. So for example, the Campbell soup can would be fair use under trademark law because it's not being used as a trademark manner. And in fact, there's different tests under trademark as to whether something is being used in a trademark way. And if it's being used in a way that's artistic, artists have much more leeway in trademarks than they actually do in copyright. It's called the Rogers test. There was a movie about a couple that it wasn't a biography of Ginger Robbers, but dancing was involved, and it was called Fred and Ginger. And there was a case, and the court said if there was an artistic reason for using those names, then that wasn't a trademark use. And that has been used in many different cases. So if you're an artist and you have an artistic reason for using a trademark in your painting, then you can do that. That's different than you're commercially licensing an RF image that might be used for a commercial purpose. So you do have a lot more freedom with artworks because it could be part of your message. There. So that would be fair use under trademark law. And the test is a little different than copyright, which is Warhol. So
Okay, I promise we're going to get to the bar and the bottles.
yeah, we're getting
coming
there
up.
close.
I
We're getting
promise.
close.
But just really quickly about just policing uses, we already talked about this, about, you know, brands that are out there looking for things. It can be designer furniture, like the Fondation Le Corbusier is very interested in looking for any Le Corbusier designer furniture. It doesn't matter how much of the furniture is displayed, they're very interested in that and have let us know that they have thoughts and feelings and law on their side in France.
In France.
In France. Yeah, in France. So at Getty Images, we don't have one single, I don't want to jinx it, but we don't have a single piece of furniture from Monsieur Le Corbusier, and we don't want it. Don't send it to us. We are not interested. And this particular photo, Nancy found it on Wiki Commons just to make sure
it was not a Getty.
It was not a Getty Images photo. We don't even have it in editorial. No, thank you. We don't want it. But also we have things on here.
Knockoffs, you know.
Yeah, and we don't want the knockoffs either because they think that's insulting to the memory of Monsieur Le Corbusier, and that's just as offensive.
Right, and
so
that's
we don't want it.
The problem with furniture in the US is that we don't protect furniture. So it's perfectly legal to make modern furniture with chrome, even if you're not Corbusier, because we don't protect furniture. But because laws are geographically bound, but most internet use is not. If it ends up in France, you'll have a problem. And that's really the issue. And then we have some things that are so protected they're aren't even trademarks. They have their own special laws. And I know, that's like the Red Cross mark is very protected for many reasons. And I remember once when they were going through every stock agency's site and looking at even little doll kits that had the little Red Cross on it. And that's always been protected for international reasons, because if there's ever war zones and there's, refugee camps, or they want the Red Cross to be protected and not targets. So they don't want it diluted and let anyone to use it. And The Olympic rings have their own protection outside of trademark law. They have sort of their
Yeah.
own
Can
Olympic.
you guys see my cursor moving
Yep.
around? Okay. So like here's the rings, obviously, and the rings are down here. But something that's so interesting to me about the Olympics is that every time a new city is announced, there's new collateral that's created around that city. So even these colorful elements that you see here in the stands, which is why I chose this picture, that's all part and parcel of the look and feel of the Paris Olympics. And if you think it's a really fun idea to submit content for Stock Paris sports, and then you include these elements in your illustration, guess who's going to find it and tell us about it? The International Olympic Committee. It's going to have something to say. So just don't do it. But it's the rings, it's the the laurel, it's the torch, and then even just Paris 2024 and how the flame was the zero. All of those things are protected, and the Olympics, they don't play. But just really quickly, the smiley, Monsieur Lou Frani, featured here, has a huge suite of trademarks around the globe with this particular smiley with the little hatches right here.
Yeah, we don't even think he owns it, but he got it.
Meltix, yeah. I Heart New York, the little tree air freshener that's so ubiquitously out there. They've put out, this is one of their full page ads that they've put in various publications over the years. I think this one might be from 2009, but they want to make sure that that is their shape. Doesn't matter if you use their branding on it or not. They are watching,
They're watching. So if you have a picture of a taxi and there's an air freshener in it, you better hope it's not the little tree.
Yeah.
And the I Heart New York, if I go back to that for one moment, that is an interesting one because that was actually given to New York by the graphic designer Milton Glaser. And it was a gift to the New York Tourist Bureau. And they have started to aggressively go after that. So after 9/11, Milton Glaser, who was still alive then, made a shirt which was I Heart New York even more. And there was like a little smudge on the heart. They sent him a cease and desist letter. He came to me and he had given it to him. So I do. Yeah, they have a law firm in Albany that goes after people. So yeah, that one gets me.
Good times.
All right, here we go.
Okay, Margaret.
Yep.
Give us some more examples here.
All right.
That Eiffel Tower, it's not registered by copyright, right? Yeah, tell us.
And it might seem weird that we're talking about the Eiffel Tower and things, but here's why. So the Eiffel Tower in and of itself, in daylight, totally okay. Totally acceptable. The light show on the Eiffel Tower, however, the creative element, the thing, is protected by copyright. So you will not find commercial cleared images of the Eiffel Tower with lights at night.
Yeah, and it's not just the fancy light show, which is really fancy.
Sorry,
sparkles and the beaming light. It's
the
even
light in general.
Even still pictures where there's nothing going on except for the light. But yes,
yeah,
protected. I learned that too.
Yeah.
Yep. And then the one that continues to baffle all of us a little bit is the actual Statue of Liberty. Perfectly okay and acceptable. The one in Vegas, however, no go.
No. Notes to self.
Yeah, that makes no sense, of course, but yeah.
Yep. So sticking with that art, Nancy, I know we're kind of getting close to time.
We're getting close. So
and we're getting close to bottles too, by the way.
Getting close to bottles. We're getting close to group shots. So outdoor sculpture in the US is protected by copyright, and we don't have any exemption except for fair use. So there's no right of panorama like some countries have. So even editorial use, you can have issues with outdoor sculpture where it's prominent in the picture. So here we have two of them. We have the bull and we have Fearless Girl, who for a while stood in front of the bull. She's now stands in front of the New York Stock Exchange. The bean, everyone takes picture of themselves, and Margaret, you're in Chicago, reflecting in the bean. That's fine for yourself on Instagram, but not for commercial use because that bean is protected.
Yep.
Outdoor murals could be a
Street
local
art,
murals, could be
graffiti
Bansky, could be
sometimes.
anyone, but those, if they're
Yep.
more than just incidental and a geographic indicator, you have to be careful. So you don't want it the main focus.
Someone's
such that-
creative work, just like a painting.
Yeah. And yeah.
And then we have other kinds of paintings. These are kind of fun.
Yes.
Okay, so the image on the left here, this is a private home, an art collection by the homeowner's child. And Getty Images, we have a release on file for the house. It's its own release. But also separately, the parents of this prodigious artist also provided a release for the artwork. Well, the mom signed it for her child. So it's good to go for all types of commercial uses. If a customer was like, but what about this amazing child artwork? We can say, no, it's released. So Margaret, for you guys at Stocksy, would you want to release too for something like this where that wall is the focus?
Absolutely. Both because it's protection for the agency and the artist and the client, but also because this is someone's creative work, even if they're 6.
That's right.
And
That's
copyright
right.
is there. We respect copyright and artists. Yeah.
Yeah. Okay, so the image on the right, that was shot at Art Basel in Miami back in 2023. We were there covering the event for editorial purposes. We had credentialed access as a member of the media. But this is just sort of a reminder. I think a lot of photographers like, I'm going on vacation. I'm going to take some pictures while I'm there. I'm going to have a tax write-off. I'm excited about it. And they just love to walk right on up to an art installation and do a full frontal photo of something and then try to submit it for stock. We don't want it. You're as a photographer, you're an artist. We want you to respect other people's work. And even when Getty Images is shooting specifically at an art exhibit, we try to make sure there's just a little bit more context going on. We have really enriched captions explaining the action of what's there. We just, we want to be respectful at all times. So just something to think about. Now, Margaret, I'm handing it over to you. This one's really interesting, and it's something everybody should consider.
And I'm going to keep it as brief as I possibly can because there's a ton of information that we could get into here. But I know we have some other pieces that are both relevant and have questions. So cultural IP. I'm just in the process of starting to really learn about it, but I think it's super interesting and something that we should all be aware of. So essentially, this comes up around the same issues of cultural appropriation that a lot of folks have talked about over recent years and sort of sorting out what is appropriation, what is not. So a couple of examples before I dig into the legal element. There's a case based in Chicago. There was a restaurant called Aloha Poke, and they attempted to trademark it. And the Hawaiian people were very displeased. They did not like the idea of a commercial entity controlling their ability to use their own cultural words, aloha coming from aloha and ha. There's cultural implications. They were really unhappy with that and sued on that. Another really interesting one that I would not have thought about is the kente cloth that you can see as an example here, which is a Ghanaian tradition. There was an outrage about kente cloths being used in T'Challa's costume in Black Panther, that this was, a cultural protected folklore element, and there was some discomfort about it being used in a commercial film. So I think some really interesting elements around here. Dias de los Muertos, the word kimono has come up in some of these.
And even some designs like Navajo designs and totem poles, if editorial and documentary use, but there's starting to be real pushback, even though there's no traditional copyright that protects it. But for brands, it can become a real sort of PR problem that you're appropriating someone's culture.
And there's I've discovered, law professors digging into this area and exploring stuff, IP in connection to human rights. There's some really, really fascinating work around it. So I mean, essentially, trademark law, as we've talked about, protects the commercial symbol, but not necessarily words or symbols that are cultural in nature. So it may not be protectable as a trademark, or I'm sorry, it may not be protectable as a trademark when it's used in a non-commercial sense, but could be. That's we've sort of talked about with trademarks in general. And some traditional works could be protected as geological indicators under copyright. But it's a really interesting area. And I think when we talk about like respecting art, this is very much about respecting cultures and cultural norms and folklore. And there's a lot to learn.
Now,
Totally agree.
one
Okay,
everyone's been waiting for.
Coming up on
we
the-
only have 3 slides left, and this is one of them, which is really great. Burning question. The bottles, similar to a bar. I mean, I probably should have used a bar instead of hot sauce. I'm much
Same
more
idea,
inclined.
yeah.
But can this be licensed without releases for commercial use? I say yes, because there are so many different brands represented. No one brand is the sole focus of the image. We like safety in numbers. We think that that's a good thing. But Margaret, what would you say for Stocksy?
Well, first I'd have a little bit of a heart attack because
It's true.
just because
Customers
like
don't always make good choices. That's true.
well, and my and sort of the gut reaction is, oh my gosh, all these brands. But yeah, I mean, I like the example of a grocery store shelf, which this gets into. But yeah, when you have this many brands and there's nothing that's a focus, it can be okay.
What do you think, Nancy?
I agree, because trademarks are based on customer confusion. So if you had this picture, the customer wouldn't be confused that one of these brands was endorsing or supporting whatever service or goods there are. The issue could be if someone just wanted to crop and enlarge like 1 or 2 and then focus on one brand. But I think your terms and conditions would have to protect you from someone sort of altering the image so much that it only focused on one brand. But to me, it's like the image of a street scene of Times Square, where there's so many brands that you can't say that any one of them would be endorsing or sponsoring the goods and services. So the difficulty, though, when you're in the grocery store or the Walmart or wherever, is if you focus on one brand, like this one here, then you'd have a problem, because almost the entire picture here is featuring Play-Doh. And so I think Play-Doh could have a problem if this was used commercially, because there could be some inappropriate
association here is Play-Doh, not
hot
sauce brands.
Right.
Yeah.
So you could write an article about Play-Doh and put this in. And
so this does speak to the liquor bottle question then. Right.
So the same as the liquor bottle, a bar where you have lots and lots of bottles. You couldn't show a bar without bottles.
Yeah.
So what you wouldn't want to do is just hold one up and make that the center of it. If
someone tried to submit this for commercial use, Getty Images would have an expectation that there would be one for the store, there would be one for the person standing in the aisle, and that Play-Doh would also be okay with it. But I'm going to blow some minds right now. Are you ready? I just learned this from our rights and clearance team at Getty Images last year. Did you know that the smell of Play-Doh has a registered trademark?
Well,
in 2018, they got a mark for their distinctive smell that's described as, quote, a combination of a sweet, slightly musky, vanilla-like fragrance with slight overtones of cherry and the natural smell of salted wheat-based dough.
Wow.
Isn't that cool? Are you like right back to your childhood?
Smell it again though.
Snacked, but you don't have scratch and sniff pictures, so you don't have to.
So cool, but it's also a great reminder that smells and even sounds can have trademarks, like Darth Vader's breathing and the sound of a lightsaber, NBC's chimes, and 60 Minutes with their ticking clock. All interesting, just fascinating.
And this is why there are many, many lists out there, because there is a lot of these things and they do not always seem obvious.
Right. Speaking of lists, that known image restrictions list that is already up on the DMLA website is good stuff.
and links to some of the other agency and resources out there as well. I often browse through all of them when I'm working on policies or calls, and they're really, really useful. So yeah, definitely take advantage of those.
Now, you guys have seen this before. I think we've slightly altered it for every versions 1, 2, and 3 of people, places, and things, but we won't belabor at this point. I haven't been watching the chat. Are there any other questions? I know we're just a little smidge over time, but I would be happy to stay on if there's any other questions or clarifying, or if Nancy or Margaret, if you thought of anything else you wanted to bring back up as we were rushing through.
We have no other posted chat questions. We do have people that have asked for the links again, and I know that there's going to be a lot of people that want to read this and watch it again because of the amount of information that was here. You guys did a great job. Margaret, Nancy, any final thoughts?
Do the work, get the releases, breathe easy.
Right.
Helps
And
us breathe easy as well as you, a creator.
And it's not black and white.
Nope.
So, well, thank you, ladies. We really appreciate it. I can't believe it. You guys are the closest you've ever been to the hour ever. So congratulations. But it was a great topic. Everyone, these will be posted probably within the next week or two on the DMLA site and on the YouTube channel as well. Please, we're sharing these in full. Share them with your teams and help us get the word out.
And refresh, and they've been great. Thanks to
so by the third one, we got it to an hour.
Yeah. Well, thanks, ladies, and thanks, everyone. Please sign up for the conference if you're intending to come.
Yes.
Get those hotel rooms, and we'll see you all in October.
And if you have more ideas for future webinars featuring,
Absolutely.
you know, the IP Riz trio, you just let us know.
Indeed.
Thanks everybody.
Bye.
Thanks, everybody.
Bye.
Bye.